Tracy, you should have the link now.
Okay, I'm waiting on it to come through. You're good to go.
I'm sorry, did you say we're good to go?
We're good to go.
Thank you. Dr. Bordelon, we are live and everybody has made it back, so you're good to start your meeting.
Okay. Please know any comments by the public are welcome and can be emailed to publiccomment@lsbme.la.gov. Dr. Collada, please confirm you verified that identified the identity of all tele and video conference participants.
Our staff has done so, sir.
Is the sound clear and audible to the public and those on the tele and video conference?
Yes, sir, it is.
Okay. All additions to the executive or public agenda must be made presently, as we will no longer make any additions to the agenda after the close of the public session. Please identify yourselves and your role. Particularly, let's start with the members. Dr. Swab.
Yeah, Dr. Kyle Schwab, committee member. Is that enough or you need more?
Correct.
Yeah.
Chris.
Chris Swallow, committee member.
Joshua.
Joshua Johnson, committee member.
Lauren.
Lauren Davis, committee member.
The others are Hallie Foster, I think, is unable to attend. Judson, I don't see Judson. Lauren?
Hello?
Okay.
Miss Davis, you have a bad connection. Are you on a cell phone or are you on the
Yeah, I'm on a computer. I know it's not showing my video either, which maybe is better for all of you, but
No.
can you hear me now?
Hear you now much better, yes.
Okay, good.
Kylie was unable to send the minutes of the last meeting. I do have some notes of mine, but they're far from being complete. I can send them to Olivia.
Joseph, what I would do is just, I would move to dispense with the reading of the minutes because they're not completed. And we'll approve them at the next meeting when we approve the minutes so we'll approve minutes at 2 meetings next time.
Okay, first, old business. The rules and regs, we discussed that, how to modify them regarding a couple of the things that came up last year. One was whether we had to make adjustments for new technology like the Inspire device, and also discussion of home delivery, sleep studies, and the poor compliance. And we also discussed other items which may need different direction, like the sleep educator. And
So I can jump in here. This is Lauren side. I worked with other Lauren, Dr. Davis, and we did some of the rule changes. If you don't mind, Dr. Van, I'll share my screen real quick to pull that up, so we can go over it with y'all.
I am not sharing.
Can y'all see this?
Yes.
Yeah.
Okay, cool. So we didn't get into the whole licensing class aspect of it. Because I think that we were going to have other people come on to talk about whether we needed to develop that class. So if we want to, we should definitely loop that in with these changes. I mean, with like maybe delay this, but so just kind of to go over what Dr. Davis and I put together. To deal with the home study issue, we clarified the definition of direct supervision. See, we scratched out the previous definition, and she helped, like we worded it. So direct supervision is defined as supervision by a physician, polysomnographic technologist, or registered respiratory therapist with an SDS who is currently licensed by the board. The supervising entity must be present in the area where the procedure or service is being performed and be available to furnish assistance and direction throughout the procedure or service as needed. Is there any corrections, approval? How does the committee feel about this change to it? Does it serve the purpose, by fixing that issue of, just kind of dropping it off and not having that direct supervision?
I think Kyle and I had talked. I think what we're trying to balance here is a couple things. That we have to look at the lay of land of what's happening in our arena. And I think that one of the entities that's become very prominent in our area has been something similar to WatchPat, where the cardiologists are ordering home sleep tests. And so we were trying to facilitate the things for that kind of testing because it seems to be, very predominant in our area right now. And we're trying to balance that with the fact that, if we look at the lay of the land in the country right now, the FDA just approved, basically a wearable to diagnose sleep apnea. And so we have to figure out what our role is in this. How are we better than a wearable, I think, is what we need to look at. And so I've gone back and forth, and I certainly want everybody's input because I'm not sure where I lie with this. Part of me says I want a, professional that's trained in sleep in the area, because questions come up, like they're getting set up on a WatchPat and they're on nitrates, or they have questions about what does this test mean, or the person setting them up realizes the patient's incapable of doing this procedure. And so I think that there's a lot of benefit in that we show how we are useful in that way, but at the same time, the rest of the country is drop shipping home sleep testing. And so I don't know where we should be on this. I think we've always been more regulatory than a lot of other states. Do we want to be more regulatory than other states? Do we want to be looking towards the future and continue to provide a lot of support services with home sleep testing. And so I think that has to be the discussion. You know, are we comfortable with drop shipping in our area? Or do we continue to want a professional there available when we're setting up home testing?
Yeah, Dr. Davis and I talked a little. I came back from a sleep conference in Southern California about a week and a half ago, and there were a bunch of sleep physicians there. Obviously, Nancy Collop was one of them. She's very well respected, runs the Emory Sleep Center, and they do mail home sleep test equipment. So, for example, they'll see her in clinic, and sometimes they leave with the study equipment. Other times, if they live somewhere far away, she has it mailed to them. She does the home sleep test equipment that most of us do, involving airflow, respiratory effort belt, pulse oximeter, and she also does some watch pad testing depending on the patient's situation, the payer, etc. So they are definitely doing and allowing mail in the equipment. The critical piece is if you have, in my opinion, if you have a board certified sleep physician reviewing the information and the patient is insured to have follow-up within, say, 30 days. Like I wrote down some things that we could potentially word in there to be sure we put some stops on it. But if the test is done by using equipment that we all agree is reasonable, number one. Number two, it's interpreted by a board certified sleep physician. And number three, the ordering physician is responsible to ensure there's some follow-up within a specific time frame. I think that given the technology, and some of these patients live, 2 hours from me that come in, I personally think we may need to allow mailing of the equipment with some stop measures to be sure it's done in a reasonable way. That's my opinion, just coming back from that conference.
How about the fact, yeah, but the fact is that she's seeing the patients beforehand. So she's screening for appropriateness of home testing and answering patients' questions and things. So, that the thing I worry about is the, direct referral for a home test and the patient's just not an appropriate candidate.
No, you make a good point, and that's true. The majority of the ones she sees beforehand, but Georgia does, from what I understand, they don't have a rule against this. So she gets patients after the study as well. And she was basically saying that, 90% of them, she doesn't have to do anything different. There are some that she may change. She brought a couple in for home testing for in-lab testing after home tests provided confusing results. But I think the technology's out there, and we just have to figure out how we want the rules to go. Like, for example, the cardiologists that are screening these patients, a lot of those patients aren't going to go to Nancy Collop. She's got a 7-month wait kind of thing. So we want them to be able to get screened, but I'll at least have a board certified sleep physician read it and someone with some knowledge follow them. I think that's, to me, the most critical, is they need to be seen within, say, 30 days of the study by a medical provider.
I'm not sure how we enforce that, because if they see it's a normal test, and they lots of times don't follow up.
You're right. I mean, there are going to be a handful of patients. There are going to be some that get home test screening that may not be optimal, but I think part of the problem is it's happening, and we have very little way to enforce it. So if we put some rules in place to ensure that it is at least managed somewhat, we're better off than where we are, because there are a lot of them going out right now. Like we talked about, Matt Abraham, he reads them on the back end, and then he does a video phone follow-up, which I'm not saying that's wrong, but he's doing it every day, probably 1,000 a month. And that's an example of it's already happening, and there are no rules, and we have very few rules in place to manage it.
My issue is mostly with follow-up. I worry that I spoke with Matt about what he does, and when he's able to get in touch with a patient, the follow-up is probably very good. but there are a lot of patients that are too far away from him and may not have ability to get internet connections or follow up from him that go without receiving their results and follow up. And that's kind of where I think we may have some leverage. So,
Yeah, I agree with you. They need follow-up. And the ordering physician, seems like to me, the ordering physician should be responsible to ensure that that follow-up takes place. So either don't order it and send them to a sleep physician, or if you order it, you realize you're responsible for ensuring they get seen. So for example, cardiologist orders it, they're going to send them here or to one of y'all, hopefully, to follow them if there needs to be some follow-up.
So we did add a little section under the mutual obligations because there wasn't really a better place to put it. But did put in there like licensed physicians providing and or billing for interpretation of home sleep studies should have a license, should be licensed in the state of Louisiana and have a mechanism in place to ensure the patient received the results of the testing with appropriate counseling regarding treatment options. So we can tweak that to see to treat to address y'all's concerns or remove it or completely redo it. But that is something that we kind of addressed a little bit.
So correct me if I'm wrong, we've kind of got a couple of different things. One is a patient leaves the physician's office with equipment, and we've changed it such that it doesn't have to be a respiratory therapist or sleep tech distributing that watch pad equipment. I think that I know we can't see all the minutes. Is that something that has been changed and it went before the board for a vote?
I don't believe so. I think that's something we talked about that we'd be fixing with these rule changes.
Gotcha.
So they're all lumped together.
On the website, the letter from May 18th, 2018 says that it has to be one of us to give it out, essentially. But then I know in a meeting we talked about Iowa and their laws, and that as long as that person did not give any instruction, basically they could pick it up and drop it off, but they couldn't assist them in any way. Then it did not have to be an RPSGT, a respiratory therapist with SDS, any of that kind of stuff.
Right. So that was when we were going to do a, like, if we're talking just in the last like 6 months, then, because I can't speak to anything that happened before I got here, but within the last 6 months, we were talking about doing a advisory opinion or, one of those on this. And then we decided, hold up, let's not do that. Instead of, let's just tweak the rules to the best we can to solve those problems. And so that's how we got to where we are right now. So we should, if anything can be addressed in a rule change, we should put that in this working document that Lauren and I were dealing with. So I think that's probably, if y'all can think of a way to make sure of how to say that in the rules, I think that's something that we could address here. It hasn't separately gone to the board before.
So it hasn't gone to the board yet. We're trying to get a clarification of what we want to go before them. And I know Dr. Davis, y'all were looking at this as far as allowing it to be distributed by a LPN or someone in a physician's office. That was one part of this. And then the other part was the mail out thing, which we initially shot down and we were discussing. But is that the way you understand it?
That's the way I understood it when we redid it, when the two Laurens got together, is that I wanted to make sure I was trying to facilitate what was going on the ground, which was WatchPat. And so that's why if you look at the wording, it's supervision by a physician, not necessarily a sleep physician or somebody boarded to sleep, but it was to facilitate the cardiologist's office to having somebody trained in their office to dispense the WatchPat. So I was trying to, like I said, facilitate what's happening on the ground right now with the entities that are working in our state. I didn't think that we were going to you can just drop ship and they get a CD or somebody calls them or something. But and I'm not sure I'm comfortable going there, but it's not my decision. But so that's what we reworded it. This was really facilitating what was happening on the ground with the WatchPat.
So basically this new wording allows a WatchPat to be distributed as long as it's under the direction of a physician, AKA a cardiologist. that has someone in their office, doesn't have to be a respiratory therapist, that distributes the equipment. That's what this is saying.
Exactly. That's
Right.
what it said.
The previous wording, there's this like little qualifier clause where it says physician or qualified health who is currently licensed, whose scope of practice includes polysomnography. And that little qualifier could be interpreted to also qualify physician. And so that would exclude a cardiologist. So the way that we wrote, like way that we rewrote it, and by we, I really just mean Dr. Davis, is physician, comma, polysom tech, comma, or registered respiratory therapist, you know, who is licensed by the board. We took away that restriction that it has to include polysomnography.
I think we're addressing the biggest issue with that. And if that's all we do, I think we've made progress. The question about the mailing the equipment, the only other thought I have, just thinking out loud, is if they see a sleep physician, maybe
Right.
it could be mail. Just that's a separate deal where they're already in your office. They live in Bunkie, and it's going to take you 2 days to get this approved. Just a thought that's somewhere between the we allow mailing and we don't allow mailing. I don't want to get stuck on this one thing. I've just been thinking about it, trying to figure out how to allow it, but ensure there were enough things in place to be sure it was done right.
So that's
I
where
think-
we added this little extra part in the mutual obligations and responsibilities. And so it just says, you know, basically, if you're a physician providing for or billing for this interpretation, you have to make sure that afterwards they receive the results, and then they also have, you know, enough information about treatment options.
Gotcha.
We can tighten this up if y'all think it should be more forceful or, you know, be clearer to
Well,
specifically
what I-
address it.
I've had multiple people come to me. I mean, I don't live in a very big place, so people know that I'm in sleep. So I've had multiple people come to me and say, I went to a cardiologist, usually is what it is. And then I go home and this thing just shows up in the mail. And it's not coming from the cardiologist, it's coming from a separate quote unquote sleep center. It's anyway. And it's no one that has anything to do with sleep. Then they get the watch pat done. And then someone else 2 hours away from them reads it, and then it comes back. And so the patient is like, what is going on? Like, I haven't seen anybody really. I don't know what this is. I don't know what this means. And then they might get a call from a DME like, hey, we got the stuff. We're ready to set up. And they haven't even seen a doctor really to tell them what is going on. That's what I'm seeing a good bit. And I know there's a ton of watch pats getting mailed out all the time.
Now, I have a question, Joshua. Are you suggesting, or are you possibly considering the fact that, you know, my wife gets scammed all the time too. They try to sell her back braces, and we tell them we didn't order a back brace. Well, your doctor did. I said, no, that's a damn lie. I know my doctor very well. But is this potentially
Right.
fraudulent stuff? Or
I don't think it's fraud at all. I think it's just a breakdown of like, okay, the cardiologist just had somebody come to them, and so they're sending them to them to do the watch pat. And then, like I said, the patients are telling me, like, it just showed up at my house. Like, I didn't go anywhere. They didn't say, hey, we're going to send this to you. It's like, hey, I saw a thing. We're going to think about doing a sleep study. We're going to set you up with a sleep study. Well, the watch pat shows up, and she goes, man, I woke up. That thing was off of me. You know what I mean? How do they get anything out of it? Blah, blah. And then that report gets uploaded from an app, the results, basically. And then it goes from there to allegedly another doctor, an actual sleep doctor reading it. In the state, it's not out of state or anything. And then it comes back. But there's been the people that have brought it to me, it's been a mess. It's been a real mess as far as any follow-up on it, they didn't know what's going on. Now there's a bunch of them that go through a different lab that it's kind of like what you were saying, Dr. Schwab, where they've been through the lab, they've been screened, they use the watch pad, blah, blah. And those go off without a hitch. No issues.
Well, why don't you tell us ideally what you think it should be like so that Lauren can put together the rules so that it reflects what the committee thinks is the proper way for these things to be done. Because I can tell you that there's a raft of Medicare scams going on all over the country now, especially with evolving DMEs. And I think we need to set some rules that say the proper way to get order and do DMEs. And I think if the issue is we got to involve the physicians more, we need to say so. If the issue is the patient has to be made aware of what's going on, we have to say so. But again, it sounds like there's two different ways it's being done. One is pretty good and one is not so good. And I think the key here is maybe we need to write the rules to draft what is good care for the patients and is in the best interest. Because quite frankly, we would expect somebody who is licensed to be involved in the training and education. And I think if that's the issue, we need to say that.
Well, I think that's what Lauren and I kind of came up with, that there has to be somebody that's either a physician or a licensed sleep tech that's in the vicinity that has trained this person that's setting them up. So they don't have to actually sit in the chair in front of the patient, but they have to be available. So, and have trained somebody so they're in an office with somebody that knows sleep. And so somebody says, this is why we're getting the sleep test. This is what it's going to monitor. And
I agree with you, and that's what we need to say in the rules. It doesn't just say who can do it. We have to define what is the proper system, because it sounds like this is not being done properly. If patients don't know what they're getting a machine for, they're not being told how to use the machine. It's not only wasteful, but it's not in the best interest of public safety. So I think the key here is we need to say, if we're going to change the rules, let's change the rules to set a pattern of what is good care for the public.
can you put in a clause that says that DME cannot be ordered or dispensed unless they've had the results reviewed with a sleep specialist? Or is that going to end up being some kind of problem? I mean, I'm trying troubleshooting here. I'm not sure how to word it.
But my issue with that would be like, for example, here, doctor sends an order, we do a test, I score it, my doctor reads it, his interpretation gets sent back to their doctor, and they see their doctor reading what my doctor said, but they're never going to see my doctor unless he ordered the test. So I'm saying,
do we want them to see your doctor? If so say in this scenario, I'm not sure where you're located, but if you're like a few hours away, but my doctor's in town or whatever the reason is, would we want them to see both doctors, like their doctor who ordered the test plus your doctor to explain it? Or do we trust the doctor who ordered the test to understand the interpretation from your doctor enough to convey that to the patient?
No, the physician, we haven't had any issues with that. Physicians are more than capable of conveying what the doctor, interpretation was and everything and going from there.
Well, I think
basically it comes down to them. Do you have it? Do you not? And what's your number per hour as far as the physicians? And they can go from there.
Really, you need to look at it like it's an X-ray report, okay? We send the person to the X-ray department, the X-ray facility, the X-ray lab, whatever you want to call it. The technician does the X-ray, the radiologist reads it and issues a formal report that's sent to the doctor, okay? Then the patient and the doctor talk about the X-ray, whether it's their mammogram, their chest X-ray for pulmonary disease or whatever it is. And I think we have to recognize that that's a kind of a consultation, and we need to say it. And it's in the best interest of patient care that the patient understand what's being done, why it's being done, and the result of the test. And I think you can say it that way, and it says it can be done by the doctor or his delegate, then that's the simple way to do it, because the doctor is then responsible for getting it done. I mean, if I went to get an X-ray, and the doctor told me I'm going to order an X-ray, that's fine. But if the doctor didn't order, nobody's going to do an X-ray. And if nobody tells me, I'm not going to go. And if I get a phone call says, and now, especially in this day and age, with the way they're trying to scam my poor bride, they call up and say, you're scheduled for an X-ray. I said, I'm the first one to say, well, who the hell ordered it? And what is it about? What kind of X-ray? And they said, well, your doctor ordered it. I said, what's his name? Because there's just a tremendous amount of scams going on. And I do think if we're writing this rule, we want to say what's good practice, and we want to say what's the best way to do it and who's ultimately responsible. Because if the doctor is going to be doing it, he's going to delegate it, but he's responsible for proper education.
So the section C is where we need to make maybe some changes.
We can also remember, we're doing this whole rule packet thingy for y'all. So we can change as much or as little as we want. Like we can get rid of it calling it mutual obligations and do like best
Should it,
practices or whatever, and then start like put all of our concerns in there, but you don't want to over regulate, and then there are certain situations that fall outside of it. So we want to be general but still specific enough for it to be applicable.
so you have licensed physicians, and should it be licensed providers?
It can be.
And then, timely,
Well, licensed providers providing license.
Now, you want the physicians, they ultimately, let me say this to you. It's one thing if somebody calls up and says, I'm Dr. Collada, the patient's going to know it's me. If somebody calls on my behalf of my office, they were always instructed, and hi, this is so-and-so, and I work with Dr. Collada. You may have remembered me. I work the front desk. Oh, yes, ma'am. Dr. Collada wants you to go and get a sleep study. Okay, where do I go? This is where you go. Okay, then the sleep study comes back to me as just like an X-ray report. I would call a patient and say, hey, I want to let you know, got your sleep study back. It looks like you have sleep apnea. If it's okay with you, we're going to go ahead and order the machine. And you want to go and see a sleep specialist or whatever you want to do. She says, oh, order the machine, and I order the DME, and that's the end of it. But I think the doctor is neat. If we're going to let the doctors delegate, they're still responsible for what the delegation occur, how the delegation is effective and how it occurs properly or improperly.
I agree.
I agree. I think it should be the order physician or the sleep specialist that read the report, that read the study.
What Joshua just said, I think is the key. Either the ordering physician is responsible for either following that patient up within a time frame of ordering it, or have them see a sleep specialist. They have to see someone to go over results, but it may not always be a sleep specialist. If you're in a smaller community, might be their family doctor, but it was read by a sleep specialist.
Yeah. So after treatment options and follow-up.
And follow up within a reasonable time after the sleep study, or?
Well, I think the ASM is that they have to get a diagnosis within 2 months of being evaluated. So you could theoretically use the 2 months.
Within 2 months. 2 months of the study, of ordering the study, of the results from the study.
I prefer a reasonable time.
Just leave it open.
Yeah.
Well, because then if someone asks what is reasonable, the answer is 2 months is reasonable because that's the other requirement.
Yeah.
But
Now,
like you said, is it from the order? Because there's a lot of places that are out further than 2 months on the order.
Right. So that's why follow up within a reasonable time frame.
Right. I would say from the time the test was done, not necessarily when it was scheduled.
From the date of the test,
Yeah.
Yeah.
Why don't you say the completion of the testing?
completion of the test.
Now, we do have a lot of nurse practitioners that are standalone and ordering tests.
Can they do that?
Yes.
Okay.
Well, I don't think we're
Do we-
saying who has to follow up, do we?
Well, I think the follow-up is behooving upon the collaborative practice physician. Are you telling me that these people don't have collaborative practice physicians, Joe?
I think they probably do, but
So if this wouldn't apply to them then, like it's strict reading of the regulations, because it just says licensed physicians providing would have to have follow-up. So if they're not technically a licensed physician, they're just an NP, they wouldn't be required by this subsection. So do we want to, unless,
Well, I think this basically says you'd have to be a licensed, if you're providing or billing interpretation, that's going to probably be a physician. And so you need to have a mechanism in place that can be a nurse practitioner or whoever. So I think the way it's worded now is probably okay. We're
Okay.
ensuring that they get the results. We're not saying who has to do the results.
Right.
Do nurse practitioners always have physicians?
They are supposed to all have collaborative practice physicians. Yes, ma'am.
Okay, okay. Then the problem would be on, okay, cool.
At least at the beginning of this session of the legislature, they do. God only knows what's going to come out of this session.
So do we want to address this in any way to include them? Because it says supervising physician, tech and technician shall bear equal and reciprocal obligations.
Yeah, we don't regulate nurse practitioners, so we can't really make rules about them.
Yeah.
You could regulate
True.
collaborative practice physicians, supervising physicians, and the techs.
You want me to add collaborative too?
I would, well, the collaborative practice physician is regulated by us.
Okay. Well, then that encompasses it.
Yeah, okay. Now, if this goes through, an insurance company could use this to deny payment for non-supervised or for studies that don't meet our criteria?
We cannot speak
Oh.
to what an insurance company can or will not do, can't do. That's an insurance commissioner's question, and it's not ours. We
And if-
regulate the techs, the docs.
Okay, if we're cool with that language, are we? Do we want to tweak anything else in this little section before I show y'all a few other little changes? But those are just really just clean up. Alrighty, let's see. Sorry, this screen. That was just a typo in the original rules for the in and out got all smushed. So that's just a change up for that. And then Dr. Davis pointed this out that we took these sections out while we were here because apparently the BRPT isn't, or one of the testing doesn't exist anymore. And that is in here twice to take out.
Yeah.
Yeah, right here.
So do we have anybody that took that test that would come into our licensing field at this point in time, late in a career?
I think they stopped like a year ago. So
Well,
I wouldn't think so.
so let me say this to you. If somebody had taken the ABSM 5 years ago and decides to move to Louisiana to get a new license, what do we tell them?
I think we should accept it.
All
We
right,
just
then-
took it out because it's not going forward. There aren't going to be any of those, but I don't see any reason why we wouldn't retroactively accept that.
Why don't you put a sunset date with that clause in there, Ms. Lauren?
To say how? To say
Applicants before X date who have this such and such credential qualify for
But-
whatever.
But they can't renew. Every year you have to renew that and they can't anymore, so they wouldn't come. They'd be expired.
So who can't
They're
renew?
talking about the ones that have by the ABSM. Every year you have to sign up again and give your CEUs and all that. If it doesn't exist anymore, they wouldn't be able to.
So the BRP doesn't do the same situation?
Yeah, they do, but they exist. The ones
Hey,
by
so
the
what happened-
ABSM,
Tell me what happened to all the ABSM people who were trained.
they had to
They now go to the BRP automatically?
to qualify for the ABSM, you had to be BRPT.
Thank you, I understand that, but now that the ABSM is gone, what does an ABSM qualified polysomnographic technician do on an annual basis to garner a license?
They're just a BRPT now.
And
They
the
generally
BRP
have both.
requires certain things?
Yeah, we 10 CEUs a year.
Okay. So then what you're telling me is there's nobody that's going to come in looking to get an initial license or renewal license with an ABSM anymore.
No, because they'll have been expired.
Gotcha.
I mean, they don't have it anymore.
Sunset. I wasn't clear on that. Thank you for clarifying.
So that covers all of Dr. Davis and my changes to this. Do we want to add anything else? Do we want to take anything out? Like, this is the time to address every and all concerns that deal with the rules. I don't know if you want to, we could potentially, like, we have a place marker if y'all approve this today to move forward for the March meeting, for the board to get that approved, or y'all can take some more time, and see it go through with it, with the magnifying glass and figure out any other changes y'all want. It's just up to the will of the board. I mean, the committee.
I think
Well,
this
As
solves
it's written now, they can't drop ship without. So I don't know, Kyle. What do you think?
I mean, this solves the biggest issue that's out there. The drop ship thing, I think there's a lot of different opinions on how to keep that from being out of control. The only other thoughts I have are, I'll give you an example. There are national companies that have some things in place to make it less likely you don't get an accurate test and the patient has to follow up. For example, and I've never read any of these, but Watchpad has a mailing service that it's mailed to the patient and then they see a physician and follow up, rather than it's just some fly by night. It comes from somewhere we don't know who the company is. But as of now, that's not allowed in the state of Louisiana. And I don't know if we want to allow it in some capacity. Sounds like the answer right now is no, which I'm okay with. I wonder how we're going to deal with this because it's happening. We don't have any way to enforce it. At least if we had some rules in place, it would keep it between the guardrails instead of right now, it's all over the place when they do get them mailed.
I know when we initially discussed it, the issue with the national companies is basically it was being read outside the states too. So now you're practicing medicine without a state license, right?
Well, the watch pet people, from my understanding, it's read by a board certified sleep physician in the state of Louisiana, but it is mailed. That I can clarify that. I mean, we don't necessarily have to solve this today. We could go with what we've got and then table the mailing and get more information on that. I think we have enough info on what we've already decided, but the mailing it opens a can of worms, but eventually I think we need some rules about it.
So for the direct supervision, we did add in a part that wasn't, or I guess it always was, that, it's licensed by the board. And then in that follow-up, we did say that it has to be read by someone, in Louisiana, so licensed in Louisiana. So at least in that scenario, they would be required to not have some Joe Schmo doctor in like Rhode Island. But I do want to say, like, the rules changes is like a lengthy process that goes between the legislature and to the AG's office. And so not that I'm saying that we want to take time to review it, but like, it's not something that we can just pick right back up, 3 months down the line and restart. I mean, it is technically, but like, it's a lot of work and it would just be really, arduous to do that instead of just waiting. So if this is something, the drop shipment, that we want to, wait till next year and, see how it folds out and do more research to see what other states are doing, then I think that's going to be fine. But if it's more of like, let's circle back in the summer, then maybe we just start that process now and just.
So let me tell you, here's a couple of examples. I know y'all see them too. There's Blackstone and there is Virtuox and there's Home Sleep Delivered. Those three are mail-in studies all over the place all the time. And for example, there are physicians in Baton Rouge that order all their studies through Blackstone. There's no follow-up, kind of what Josh was talking about. So they have these right now, they're all kind of wild, wild west kind of thing because we don't have any anything in place that can control it. I think when it's WatchPad, if it's read by a doctor in the state of Louisiana, I know they're all supposed to do that, but they're not. So if we had some way to keep this between the guardrails, I think it would be good, but I don't know if we're all be able to agree on that today. So I'm okay tabling that for a year from now, if that's what Dr. Bordelon and Dr. Davis want to do. I don't know what to do with it.
Well, I think we kind of have those guardrails already, because we're saying that it has to be interpreted by a licensed physician in our state. We can discipline licensed physicians in our state for doing testing that nobody's following up on, right?
Yeah.
Provided we get a,
This,
absolutely.
this would do it.
Well, and we still have the option of doing an advisory opinion or a statement of position to address it in the interim if it becomes something that's like totally, if it just totally goes off the rails. You know, we have that interim ability to address it.
Joseph?
I really worry about the drop ship stuff, because we have responsibility to the public, and so many of them are not going to be able to deal with this unless they have some interaction with professionals. So I like this. I think this gives us some options.
Does this effectively address the drop shipment issue?
If you don't, I think it does. It restricts it.
Okay.
If some,
How do we, this is my first time doing like rule changes like this. How do we tell the people in the field? Because I feel like this is kind of nuanced, like these changes, and they might not realize like, oh, hey, this is what we're dealing with.
Okay, so there are two ways that happen. Number one, we notice everybody in the field of the new rules. Number two, Susie then amends the law and rules course for the field. And then we refer everybody to, we suggest everybody take the new law and rules course, which is available for free CME, for the board's requirement for CME, I should say. And then that way we make sure that they get their opportunity to learn and read. I don't know that you can do anything else other than that. We have the ability to send them the notices individually. We can tell them that the law and rules have been modified. They should take the new law and rules course. And after that, it's going to be an issue of correction based around complaints.
Yeah, and also I guess there's also the the public comment portion of the APA or the LAPA.
Yeah.
Right, but in terms of publicizing it to the average practitioner who's not politically or that on top of it, we also make note of any rulemaking activity in the newsletter if they read that. And then I think if you have any kind of trade association or occupational associations or societies, if you all are members of those, you could bring that up at one of those meetings too once it's passed.
Right, so they should know.
Joseph?
I like these changes. I think we ought to take steps to allow it to proceed on the road to finalizing it.
I agree. I think it's stepwise. I don't think that we can just open up the doors, but I think this is a step that kind of looks at the lay of the land and adjusts for what we have right now and tries to put some guardrails in.
I agree too.
I agree. I'm not completely against, drop shipping, because I understand, like Dr. Shaw was saying, there's in Louisiana, there's a lot of rural places. You have people coming from way off. It's just not feasible to say, hey, come pick this up, and then I need it back by 7 or 8 o'clock in the morning the next day. And it just doesn't work. So I understand that, but like I said, the oversight here is what we needed. We need something where they're actually getting some help, though, not just, hey, this showed up my doorstep and what am I doing?
And I think that, if we look at the other thing is, if you're seen in a sleep physician's office and we see patients from Mississippi, my tech sits down and talks to them about this is how you put the equipment on. This is what we have the equipment there, but it's going to be shipped to you when we get authorization. I mean, that's drop shipping, but that's not drop. They get direct supervision of how to set up the equipment. Is it appropriate? Their answers or questions are answered. So you can still, there's a way to quote unquote drop ship where they get the direct supervision of how to use this equipment and why we're doing it.
Yeah.
And that's exactly what this would envision, right? Like that's kind of the best case scenario to have it both ways, and kind of what we envisioned, right? Like crafting this definition of direct supervision. Like you still have to be told everything, but it's fine if, someone just drops it off, or, you end up getting, whether that's
Dr.
UPS
Davis.
or like a nurse.
Yeah, that's good. Dr. Davis, question for you. What do you think about if a patient is seen in your office and they live in the hinterlands and they've already been seen by you, you could drop ship it in that circumstance? I haven't never done it, but there are times where it's a pain for the patient to take stuff. They live in Natchez, Mississippi. They got to bring it back. So in the case that they are seen by a board certified sleep physician, it would be an option. It may not happen often, but right now it's not an option. I have to tell them you can't do it. What do you think?
Well, here's where I step in it then. Yeah, I've done in my office maybe 5 times. I got some samples of WatchPat and I was trying to figure out, do I like it or not? And what I did is the patient was from Mississippi and my staff sat down. We had a WatchPat in front of them. We showed it what it looked like. They put it on. We showed them how to put it on. And then we said in 2 days, it'll probably be mailed to you because we need to authorize it. But they got direct, this is the equipment. This is how you put it on. Okay, you can put this on. A sleep physician saw them, said, this is why we're ordering the test. This is what it entails and what it's going to show me. But they can't drive to pick it up in 2 days and then drop it off the next day. And so I'm hoping that comes under this. They have direct supervision on how to use the equipment. They see the equipment. They know why they're having the test. They're appropriate for that type of testing, but maybe they didn't take it home that day. So I don't know. Is that going to cover that? I don't know.
I don't either. I haven't done it yet because I didn't want to overstep. But in that case, it's a different animal. They're not getting it from Blackstone with no follow-up. You've already seen them. And like you said, they've gotten supervision. But I've been making them come back and forth to Natchez when I would prefer not to, just to get the test equipment.
Like I said, I've done it about 5 times. And I think that, they were trained and they saw, they were screened, they were trained, direct supervision. I was in the office. And so, but, whether they actually take the equipment that day or take it another day. We sometimes, if we don't have authorization, we train patients on CPAP machines. And then we say it's going to be dropped off at your house in 2 days. And so there is direct supervision of training on how to perform it, the procedure. And so I would think that this would be covered, but I don't know. What do people think?
Dr. Claude, are we covered on that? What Dr. Davis and I are trying to say?
I think that's going to have to be clarified in either an advisory opinion or a statement of position from the board, because I think that what you really, this is an evolving technology, but I think the key is just because it's evolving doesn't mean it shouldn't be done in a proper way. And I think we can clarify that. If you don't address it adequately enough, we can. But again, I think if you want to add them in the rules right now, let's do them. But I have one comment I've been trying to make, and I thank you for letting me speak. The ABSM will continue to offer RST certifications through 2032, when it will then publicly sunset the credential. So people can come in with the RST.
Yeah. I thought it ended last year.
I'm sorry, 2032.
So that's
I don't think they're testing any longer, though.
Again, they've
they'll
issued
still
their
be
last
able to renew.
exam, but they will continue to offer recertification.
Yeah.
Okay.
So somebody can move into this state with a RST until 2032. And I think you need to address that in the rules now, because when it happens and you're covered.
Well, then let's just leave it and not take it out. And if we don't ever use it, And when no one applies with it, then, no harm, no foul. And then we can
I
take it
agree with
out
that.
next decade.
So we're gonna, but basically then the rules are gonna say that they
What they
have BRPT, and somebody comes in with a valid RST credential in 3 years that's been renewed, we're gonna say you can't be a licensed examiner, a licensed person.
So are they still offering the credential just without the testing?
Okay.
Nah.
So
So
what they're offering is no more new ones.
Yeah.
All of the people who
Just
have them
renew.
can continue to be certified by them until 2032. So if there's somebody took the test 4 years ago, they can stay RST certified until 2032 is what their webpage is saying.
Okay, so then let's just leave it in and we address this in 2032.
That's fine with me too.
Oh, we're gonna
That
be
sounds
here.
good.
Perfect.
That way we don't have anybody, that should be able to be licensed that then isn't.
And in 2032, I'll be gone, but you'll handle it, Lauren.
Yeah, I'll calendar it now.
That's right. That's right.
Okay, cool. Well, thanks, guys. This is what y'all be voting on is the contents, not all the extra stuff. I was just working on the notice, so it has all the jazz about the financial nonsense and the property statement. So like that part is we're not voting on that. We're just voting on the actual edits to the rule change. This document will be, all of that will be stripped away. All the excess parts of this will be stripped away, and that'll go to the board for them to approve the rule changes. Obviously, I'm sure Patricia and everybody, I've told y'all this, and y'all know this how it works. They could take our recommendations and approve them. They could completely deny them. They could completely change it up, or they could say, like, we don't like any of this, come back and redo it. So the board is not required to act any sort of way on our recommendations, but I mean, they obviously view y'all as the experts in this field, and so they're going to take everything, adequately weighted of importance. So just wanted to let y'all know that this will be going up. Hopefully we have a placeholder for the March meeting, which is next Monday.
A week from Monday.
A week from Monday. Yeah, not this one, the next one. So if y'all want to come in case they have questions outside of it, you're more than welcome to. Just as any meeting, it's a public meeting, but don't feel like you have to. It will be in person. So it'll be at our office, 630 Camp Street. So yeah, the only thing we need now is to take a vote on this.
Do we have
So
a
just-
motion
Well,
to
I would
accept?
just add one more thing real quick. It's an in-person meeting because the board will all be in the same place. Some staff, because we still don't have access to the board room on the 5th floor, some staff members will still be participating by Zoom. So if any one of you wanted to have the Zoom link to the meeting so that you could just watch it during the point of time at which the item that you're interested in is coming up, if you wanted to be ready to send any comments to Dr. Collada or be allowed to speak during the Zoom meeting, you would be considered a guest of the board at that meeting and you could appear virtually.
Yeah,
I would love to listen to it.
if you're gonna come, you're gonna climb 4 flights of steps.
So are we putting out a statement about this, about everything, or would that be after the meeting or?
Well, it will
I
be
guess
on the
first-
it'll be part of the proper public notice of what's on the agenda, which is we conform to state law in that regard. Now, having said that, the actual language will not be in the agenda, okay? So what you approve will be in the agenda, and that's all we can say. And if anybody wants to appear to talk to us about it, that's fine.
Okay. I was
Okay,
just making sure that the people that we were making this for would actually see it and actually be aware of it. And if they were in violation, would know.
Yeah, so it goes to the board for this to start the rulemaking process. So they have to approve that. Then it gets, published in the register. Then there's a 30-day public comment period in which people can send in public comments. They can come up and tell us, they can email them, they can send them, snail mail. And that then we can take those comments and incorporate them or not, consider them in the final version of the rules.
So, yeah, the notice of intent to proceed forward with the rules after the board approves them is published in the register. That's not something that the average person sees. Again, it is certainly something that you all could communicate if you have, you could consider asking Dr. Collada to blast email the licensees in this category, just as an FYI. It will be in this next subsequent newsletter. So it's just an issue of how directly you want, short of a phone tree, how directly you want to communicate to people that this happened. It will be communicated in multiple ways. It just might not be as completely direct as you desire, and we can work with you on that.
so it would be communicated to the licensees.
It can be.
Is that after the board approves it?
Joe,
Yes.
again, I want to make sure you heard what Lauren said. This first process is the board saying, we like what you want to do, we authorize you doing it. Or we don't like what you're going to do, we want you to change it. Or we don't even want you to do it at all.
Okay.
At that point, we start the formal rulemaking process if they approve it. That's when the public notices are sent out by the normal mechanisms of the state, which is the register. Then there's a period of 35 days for public comment, and we will probably have a hearing at the office where people can come also and comment. Then after that, the board relooks at the public comments, maybe makes changes or doesn't make changes. Then it goes to the Attorney General's office to make sure there's no antitrust implications. And then from that point, then it goes back to the board, and the board does final notice. And even at that point, somebody can say, I want an oversight hearing by the health and welfare committees on this matter. If the legislature does that, they have 35 days to do that. And then if that doesn't happen, it goes to the governor's office for approval. Lauren, did I tell him right?
That's my understanding, yeah.
Okay.
So will the meeting on the 25th with the board be public, or do we need
Yes.
it will be
It's
public?
public, but it's an in-person meeting. So the average member of the public would need to come to 630 Camp Street and walk up 5 flights of stairs to sit in the boardroom. You as advisory committee members and the board's delegates, in a sense of for the expertise in this subject matter, and the people who are making the recommendation that they adopt these rule changes, they believe it would be appropriate for you all to receive a Zoom invitation so that you could actually observe the meeting remotely and be able to ask questions or make comments at that time. If you chose to do that. If not, we'll let y'all know what happened.
I guess another thing, just the board meeting might not be the best. I mean, it's totally allowed and totally legal, and I'm not trying to dissuade people from doing so, but it might not be the best time to email blast this out to everybody and say, come to the board meeting to raise your concerns. This is more of the way to understand it is that the committee is not making the rule change, the board is making the rule change. So in order for the board to start that process, they have to approve it, and so we can do it. And then, so the way to get the most effective consideration of any actual text concerns would be during the public comment period of the rulemaking process.
That's right.
Okay. Yeah, I'll be out of the state, so I won't be there. But I'll just check and make sure. Okay.
Susie has her hand raised. I don't know if she has something to say.
Yeah, I just wanted to reiterate in terms of some of the communication options that Dr. Van and Patricia and Lauren have discussed. the quarterly newsletter always talks about what rules are going up, et cetera. In this particular case, so at the end of April, something could go out, saying this, just reiterating this is what's going on. Again, we have the option to also do blast emails to polysomnographers and physicians if you want to. The other thing that I wanted to mention is that this may, if listening to some of your issues, it in addition to sleep physicians, you may want to make sure that the membership organizations of any referring physicians, such as cardiologists, also are made aware of this, whatever. So, if you want to make sure that that patients are appropriately advised of what the test is and who's doing it and so on and so forth. So just wanted to reiterate a little bit of that and draw your attention to that. But as Lauren said, this board meeting is really just the first time the board looks at it. You go from there, and there are plenty of different ways to communicate with the appropriate audiences after that occurs.
Okay, do I have a motion to accept the edits of the rules and regs as stated or as listed?
Motion accept.
All in favor?
Aye. Aye.
Aye. Chris and Judson?
I said
Yeah, I said aye.
Me too.
All right. The motion carries. Any against? We can move to the next item, I guess, on the agenda.
Like, did we ask for public comment? I'm sorry, I kind of spaced for a second.
Okay.
An email. Was there any public comment?
Let me double check, but I have seen none. 1 second. Give me a minute. And there's no public comment.
Okay.
And by accept the changes, the motion encompassed the notion that Lauren will now take this to the board as the committee's recommendation and ask them to approve promulgation. Is that right?
Yes,
Correct.
and that this document is only the rules.
The recommendation of the advisory committee for a rule change by the board.
Can we just do an extra, everybody say aye again, just to make sure, no, after public comment, after that clarification?
Aye.
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 Thanks. I did open meetings at the AG's office, so my tingles sometimes, with these sorts of things.
Lauren and Judson reply.
Yeah, I did.
Yeah, I
Aye.
did. Aye.
Yeah. All right.
All right. So if Lauren, you'll stop screen sharing, I'll start screen sharing the agenda again.
Yes, sir.
Thank you, ma'am.
So the next item on the agenda is the rules course.
Okay, I don't have much to say other than I was working on this as with Dr. Bordelon and Kylie Foster, and then we were sort of working on finalizing some of the questions. So I am hoping to finish up the course and get some additional questions and so on from Dr. Bordelon and Ms. Foster, and maybe try and get this up late April in the course. Now, that being said, you have a rules, change effort being, in the works. But I still feel like we need to get the course up with the existing rules. I can certainly add a section saying, that describes particular changes or not as the committee feels is appropriate. But we sort of had a delay just because of some other inner workings of the board on this, but I want to get back on the horse and sort of get this up. So I just wanted to give you a little brief update about that and entertain any questions about it.
So the rules course would be for newly licensed or for renewals.
Well, no, the way it works now is that, we require people who are, new licensees who are renewing for the first time to take the laws and rules course so that they're familiar with the contents. We also are using these rules courses in cases where someone is disciplined by the board. For many of our licensees where that happens, we also ask them to take a rules course in their respective professional area to make sure they fully understand them. We also, it is not, level 1 AMA or sponsored by your particular professional organization, but it is board approved CE. So we also put things in the newsletter saying, hey, this course is there. If you haven't looked at the rules ever, or you haven't looked them in years, we strongly recommend, that you take the course and you get, I haven't decided how many hours CE this is. I really look at the length of the course and the time, but we do encourage people at all times. Theoretically, someone could take it once a year, and definitely when some of these rule changes go in, we would certainly, send out email blasts to the polysomnographers saying, hey, look at this. We encourage you to take this because, there are changes and you should be aware, and so on and so forth. So that's generally how this works.
Okay. Any questions, comments? Hearing none, we can move to the fourth item, home sleep studies. Most of this may have been covered in the rules and regs, unless anybody has any additional concerns. Hearing none, do we need to ask for,
You just move on to the next item on the agenda.
You're not taking any action, so you're fine.
okay. The next item would be the role of the patient educator. Any comments here?
Are we going to be able to devise a licensure for that entity, or how are we going to address that? I mean, it's something that we're seeing them out in the field, and they are, working in offices and doing liaison in the hospitals, but I don't know that, where they fall as far as regulation or licensure. We don't have a sleep educator license. They're not really polysomnography techs. I think we need to try to address it on some level.
Let me ask a question. If you want to set up a license class, is there a registration system? Is there an education system? There are a lot of things we need to know to license somebody. And how do we determine that they're qualified to even receive the license once we determine what the qualifications are? So
They have testing through the AASM is how, or no, BRPT is how they're doing it now. So the same entity that licenses the polysomnography techs also has a pathway for sleep educator.
So is this something that this is their occupation and they bill for it and there's an insurance code for it and stuff?
Well, that's kind of what we're trying to figure out, because they are working in the sleep clinics and they're seeing patients, and some insurers are paying for it. I guess I don't have one in my office, but I know Dr. Connolly does, and he was saying that he has difficulty because he wants them to have an NPI and be able to bill, but they don't really have a licensure or they're not, an entity that people are familiar with. And so, but I think there are more and more people coming through the pipeline. I know one of my respiratory therapists in my office is trying to decide whether to do that. And our sleep clinic has somebody that's in training to take that test as well. It's a pretty extensive test. I've looked at the curriculum. It doesn't have anything to do with like EEG and performing overnight testing. It's more of a, educating patients on, sleep and being a liaison in the hospital when patients are high risk for sleep apnea, how to get them into the system, make sure they get testing and education and things like that. Lots of times I know Dr. Connolly, what he does is he develops a treatment plan when he meets with the patient, and then he hands them over to the sleep educator to talk about, humidification issues or whatever issues he feels like they need education on.
Wasn't there someone who had recently taken the test or had gone through it that was supposed to come talk about it, or that we were going to reach out to? Is that this committee or no?
No, it's a different one, but I have a suggestion. Since Lauren is going to is developing up into our resident legal expert on polysomnography, how about if you ask Lauren to do a little research into the state of this profession and what other states are doing and how they're handling, credentialing, if any, and then report back to y'all at your next I don't know when your next meeting is, as soon as it's reasonable for her to do so.
That works for me.
I have a question. Are they involved in CBTI for insomnia therapy?
I think they can be.
I mean, because that's probably the greatest unmet need.
But why don't you, are you okay with letting Lauren look into it and bring you back some information and options and just some ways that other people are handling this and so forth?
That would be amazing.
Dr. Davis,
Yeah.
if you can you just shoot me an email with kind of the parameters of what aspects you're concerned about? That way I have something to completely refer back to.
Okay, sure.
Thanks.
Any other comments or questions? Are we clear to move on to the next item?
There are no public comments at this time.
The sixth item is the Inspire procedure. In the last meeting, we had discussions about this and whether we needed wording to address the performing of the studies, whether it needed special rules and regs for this new technology. And I think we had Lauren had submitted some documents
Yeah, I
last
think
time.
we had left it that we were just going to leave it under, there are new technologies being developed all the time, and we should leave the responsibility in their court to continue to have education of new things coming down the road, if I recall.
That was my understanding as well, that we kind of tabled it for right now because we didn't want to be sending out, advisory opinions on every new tech that came out. That were just the concerning aspects with Inspire do fall under the rules. And so if anything does come up, we can just handle it with the existing and now the new rule changes.
The Inspire Corporation doesn't, you have to buy the analyzer from them, and they do not let anybody do a study that they have not educated. At least they come on site about 5 or 6 times and do the patients with the ticks. I can't see anyone going outside of that.
Any other comments?
I think we're pretty comfortable with what's being done now, and we didn't want to look for problems until a problem arose, I think.
Yeah.
Okay. Questions? Any new business? Next meeting? I do have a question. I'm living in Texas now. Will I have to be replaced?
Are you licensed in Louisiana?
I'm licensed in Louisiana.
Yeah, I think I looked back at this a while ago. I don't think your nominating and appointing statutes or rules require that you be resident in state. I'll double check that, but I know it was this one and another. I think respiratory therapy too had the same situation, and I think I double checked that for everybody. But I will check again just to give you a comfort level.
Okay. Any other new business or old business or?
I just want to remind you, you do have an executive session. You have one thing there to speak on.
Oh, we need to move into executive session?
Yes.
Yes, sir, you do.
Okay.
Give us a few minutes to transition everybody
Just
into
need them to,
the
committee
non-broadcast.
to vote. Dr. Bordelon, I just need your committee to vote to go into executive session.
We have to vote. Do we have a motion to go into executive session? All in favor?
A motion. Aye.
Aye.
Aye. Motion carries. Okay. So we need to join the room.
Yes, sir. Tracy, I'm gonna leave you outside the room.
Okay.
Dr. Van, are you having issues moving?
I'll try again. It didn't let me. Oh, here it goes.
Okay, Tracy, now you're by yourself.
Perfect.
Everybody's back?
Yep.
Yes, sir.
So we have no actions that we need to take from executive session. Any other new business? Do we have a motion for a future meeting?
I would just say after the board meeting, the LSBMA board meeting, so sometime in April if you'd like, or you can push it out farther.
In April or May,
May's good.
early May?
It doesn't matter to me.
Yeah, it doesn't matter. Midday is always better.
Do y'all have anything open first week in May or last week in April for Friday?
Hang on and we'll look.
We can do Friday, April or May 3rd if you'd like.
Sounds good.
Anybody have any objections to that at 11 workout as well for everybody?
Yes.
11.
All right, May 3rd at 11 a.m. I will get the invite sent out to everyone.
Thanks.
You're
And
very
thanks
welcome.
y'all for all you've done today to help us out. We appreciate it.
Thank y'all.
Yeah, thank y'all.
Thank you. I guess it's closing.
Yeah.
All right. I was late and I didn't want to get off early.
Bye-bye.
Sorry about that. I apologize, guys.
Bye, bud.
Have a great weekend.
Everybody have a good weekend.
Me too.